back in 2002, I authored a piece of legislation that was really very simple, but has had, frankly, a more significant impact than I imagined at the time. And the legislation I authored said this: if you're holding somebody's data in your database and you lose it, it gets stolen, hacked, compromised, then you have to tell the people whose data has been put at risk. Sounds pretty simple. So if somebody's got information in their database for 500,000 consumers and somebody accesses that information, then they have to tell those 500,000 consumers, hey, somebody had access to your information, your personal information. And the notion behind that was twofold. First, that we needed that information as consumers to protect ourselves. Rather obviously, if you don't know you're at risk, you can't take steps to protect yourself. What you don't know can hurt you. Or as one of my colleagues said, ignorance is not bliss in this case. You need to know that you're at risk so you can protect yourself. The other hope, and this has proven to be the case, was that if companies had to send out a notice to 50,000, 100,000, 500,000 folks and say, hey, we're sorry, we lost your data, that both the cost of that and the embarrassment and damage to reputation would encourage companies to step up a little bit more and do a better job in terms of guarding the data and having privacy and security protections in place. And that has in fact been the case. We know that from talking to security professionals around the country. Doesn't mean it doesn't still happen. People say, it seems to me the problem's worse than ever, and I smile a little because I say, looks that way because now we know about it. Before, when it happened, we didn't always know about it. Now, if there's a security breach, we know about it, and it has been so successful here in California that more than 40 other states have essentially copied California's law and have similar laws on the books.